What's up? Kind of wait for some of y'all to come in. You know what time it is. Once you break out the jump off right here, boom. It says don't need the person who receives a gift to whom a gift is made. Okay, we gotta charge this one. What's up? How you doing? How's everybody doing this beautiful Sunday? Almost spring again. You know what time it is. Come on, let's keep it real. I gotta go back in it, straight up. What's up, bro? What's up? How you doing? I gotta go back in there. All right, old country, high rollers. You know what I'm saying? I got yo country. I gotta go back in there. You know what I'm saying? I gotta get back in there. I'm cracking up because, like, in the situation, okay, when they bring you up on charges, what they're gonna do is they set a date. So we're gonna go with the employer who, labor relations, who basically set up a hearing at the facility. Set up a hearing, okay. But you gotta understand, the officer filed a complaint prior to all of this nonsense, right? So in filing the complaint in the fall of 2008 of corporate compliance violation, in violation as well as New York State traffic law, New York State penal law. Now, being that the probationary hospital police assistant deputy director was on probation, period, for 1 year, and this will warrant the fact that he broke these laws under the employer's personnel rules and regulations. Was that 5.2.3? This any acts of gross misconduct will warrant him to be terminated effectively immediately. But we're gonna go by that. We're gonna go past that because that's still what they did was, the EEO didn't want to look at it. She took and hit it. Okay, she hit it to the side, and they wiped their ass with it. So let's move forward now. The EEO did tell the officer that she's setting up a meeting. She told the officer this like late December, early January. And that was around the holiday, Christmas, basically Christmas party time and New Year's time. So she told the officer that she's setting up a meeting. Granted. Now, this occurred in July. The EEO complaint by the third incident was made in October. You have up to a year. As long as you inform management in the whole 9 yards, you're good. You have to inform management first before going outside. Since then, it's been changed. Since 2012, it's been changed, but you have to go inside first. Okay. Now let's move forward. The based on the fact that these charges are brought against him, or this complaint is brought against him, they, working with management, they found a way to try to use to retaliate. So in his actions retaliate, he used the time where in July, from the July incidents where he gave the directive not to let the employee go into his parking lot. His assigned parking lot, which you pay for parking. He said, don't let him in there. Tell him to park in the visitor's parking lot or on the street. This is a contract, right? Yeah, so you basically breached that signed contract agreement right there. So in breaching that contract, that was a form of discrimination. Okay. In that being there, that also brought in the what you would call the Jackie Robinson, U.S. Code 42. Deprive a person of a right or privilege. You deprive of something. You don't have a right to do that. So let's move forward. Now, being that that action took place, it warrants what we call corrective and preventive actions from the employer. The employer must take corrective and preventive actions, which the EEO says she set up a meeting, and this meeting will be about the corrective and preventive actions. Okay, now, here goes how stupid they are. The EEO set up the corrective and preventive actions meeting. Great. But the facility came up, labor relations came up with their meeting for harassment. Yeah. Okay, let's go further. All right. If you're going to set up a hearing for, they set up a hearing for time and attendance, some certain charges, that they brought up. But you got to understand, you held the time and attendance meeting or the disciplinary meeting against the officer prior to the corrective actions meeting. Do you ever heard of due process? And here's the key. When the officer told the labor relations specialist that he filed a complaint with the facility's EEO, all the specialist, labor relations specialist had to do was this: hold on, go in the next room, call downstairs, or right in that same room, call downstairs and says, did this officer file a complaint with you guys? And they say yes. Okay. Thank you very much. I'll get back to you in reference to that case and hang up, and then take and say, we're postponing these actions as of right now pertaining to an ongoing investigation based on a complaint filed by the officer. Now, once the officer told you, you are obligated to do this. This will bring a mayor order, executive order number 16, because he told you what was going on. He told you that not only was your corporate compliance violated, he also told you that, in that action of violating the corporate compliance policy, certain laws are violated. So this warranted the corrective and preventive actions meeting by the facility's EEO, which never took place. I don't understand. What's happening, Muhammad? How you doing? What's happening? I don't understand these people. Like, you got to follow due process. I don't understand these people. You get in a position, in a professional position, because you're getting paid for this. All right, you're working a good, decent job in the whole 9 yards, and you get in there. I'm sorry, our people. I can do what I want. And if I'm not gonna say our people, I'm the people. I can do what I want. You can do what you want. Do know you work for a governmental entity. It's a governmental entity. If you need to know, all jobs and businesses are governmental entities. I want you to sit there and say, no, they're not. All jobs and businesses are governmental entities. I want you to say, no, they're not. And it's going to hit you with this brick, real simple. Do they have to register that business with the city, state? Let me change that. With that township, with that borough, with that city, with the state, or with the federal government? Now, also you want to take this other one. Do they have to follow the guidelines from the feds on down? We're not going to go from the city on up, or from the township on up, from the feds on down. Do they got to follow those federal guidelines? Yes, they do. So being that they're registered, once you register that business, you're actually turning that business over to the government. You're following their guidelines. You're being allowed to conduct business within their corporation. It's not that hard. It's not that hard. And I mean, I just had to come on in and hit you with that. I'm like, how is the labor relations officer or labor relations specialist going to continue with a hearing, even though or meeting, even though the officer gave notice that there was a complaint filed against the probationary employee, all right, which happens to be the hospital police assistant deputy director at the time. That's the title he had. There was a complaint filed, and there was supposed to have been corrective actions taken. Now, you got to understand, well, we had this hearing on the 31st of March. When did the facility EEO set up her meeting? She lied and said she set it up for April 6th. Let me show you in the criminal act that they're doing where they're going to lie. I set up a meeting for us for April 6th. You did? Yeah. Dum had a hearings meeting before that. Oh. This case is so criminal. We look at what's in the news right now, the top dog. Somebody just sent me an email, and I just sent them an email right back in reference to it. Why would I throw stones at his situation in the whole 9 yards when you don't have the true facts? We don't know what's going on. When I had my own situation and did it the legal way, and nothing was done. And that's on a civil servant level. And if you need to know, civil servant is property. You own your job. Why? Because you paid for the test and you passed the test. Then you pass your probationary period. So technically, it's permanent employment. You own it. The only way they can take it away from you is the act of due process to Civil Service Law Section 75, I believe it is. Of law enforcement is Section 76. But that's the only way they can do it. And that it must be incompetency or misconduct within those guidelines. There was no incompetency and there was no misconduct. Everybody lied. Supervisor lied. I called him as at 11:45, 23:45. You did. Was it on the clock? No. Was I scheduled to show up there? Yeah. By your own documents, I was scheduled to be there. Did you send the vehicle? No. So that right there is an impropriety. Your entire case is an impropriety. That's supposed to be thrown out. Administrative law judge, you're supposed to avoid improprieties, even the appearance of an impropriety. That is an impropriety. The other supervisor says that he wrote this incident up in his memo book 2 days later. If an officer writes something in their memo book 2 days later and they catch a rip, what happens to a supervisor who does the same thing? That's a rip. That's a rip. If they write something fraudulent, such as the other supervisor who writes fraudulent stuff in people's memo book, that's a rip. Let me help you out. A memo book is a legal document. And as long as your signature is there and on that legal document in your hand script, all they have to do is show that legal document. That actual entry, what you said, you told them, that's a punishable instrument now. Punishable. Did you tell them? No, you didn't. You're on the camera writing in the book while the officer's in the bathroom. If you told the officer, you should have told him right there. You forgot there's a camera above your head. There's a camera above your head. And you wrote the lie and put it back in there. So when the officer goes to his memo book and sees that you wrote this, you didn't sign that you was there. You wrote a lie that you told the officer something. You didn't tell him that. You wrote a lie. I got that memo book. I think I need to post it. That would be fraud. Punishable? Punishable? Yeah, that would be 21045. Class A misdemeanor. The mere fact that you wrote it. 19500. Official misconduct. You didn't offer it. You didn't turn it in. See, if I'd have gave the book in, it's considered the same as turning it in. But I think they got that book. I think they got it. They might got it. They don't. I'm going to check and see if it's over here. I'm going to put it up there. Let everybody see it. Fraud. Right there. Fraud. And I'm not the only one you did that to. You did it to someone else. Wrote up a lie. Had them face some time in the street. What do you think? I don't know. I got a lot here. It's nice out. I'm not going to hold you guys up. It's coming around 3. It's time to start the burning. You know what I'm saying? Get that dinner ready in the whole 9 yards. But you know the deal. The facts cannot be altered nor denied. You guys have a wonderful afternoon. And I'll holler at you later. Later.